risk mitigation. Thanks for joining us today. We've got a great panel and great agenda for you to hit and for us to cover today. We do want this to be interactive, so please make sure that you ask questions as we go along. And if we go to this slide, you'll see that Q&A button at the bottom of the panel. I'll be monitoring that and interjecting where we can along the discussion. We'll try to do that if possible, and if not, we'll certainly do it at the end, time permitting. My name is Dean Gutowski. I'm the CRO at Gimmal. It's sort of inaccurate insofar as Gimmal's recently been acquired by Morae, which is a legal technology company. And so happy to say Gimmal software is now being deployed by Morae, and that deal just was consummated, I'd say 30 days or so ago. So happy to be on here talking to you kind of as part of that new joint entity. I'm an attorney by training, been doing e-discovery and information governance for longer than I would care to admit. I was going to give an actual range, but let's just say a long time. And I've known Martin a good chunk of that time. So, Martin, I'll just go left to right. And that was kind of a segue, not to leave you out, Lisa, just I was talking about Martin. Martin, why don't you go and do your intro?
Sure. Thanks a lot, Dean. I appreciate it. And of course, you're appropriately leaving the best for last, and that's Lisa. Yes, Dean and I have known each other for a long time. I've also had the pleasure of knowing Lisa for a good while. So it's a privilege and a pleasure to be here with both of you. Real quickly, again, my name is Martin Tully. I am a litigation partner with the law firm Redgrave LLP. I am with the Chicago office of the firm. Redgrave, for those of you who may not know, is a boutique law firm that focuses exclusively on electronic discovery, information governance, data privacy, and cybersecurity. And in my spare time, I also have been the former chair of the Sedona Conference Working Group 1 Steering Committee, which folks probably know focuses on electronic discovery and information governance, and really pleased to be here. Thank you.
Thanks, Martin. Lisa, over to you.
Thank you. Hi, I'm Lisa Luback. I'm the records manager with DaVita. It's a kidney care, large organization. I've been with DaVita for just over 2 years in their records program. Previously worked in the insurance industry for over 20 years, much of which was spent in records management and information governance. I've been an active member of ARMA and have had the privilege of working with Martin for several years.
All right. Well, thank you guys for joining us today. Disclaimers, most folks realize this anyway. We will not be providing any substantive legal advice, and so all of our comments don't reflect necessarily on our current companies or are giving you actual legal advice, but we will give you our opinions. And with that, let's get started with some of those opinions. Let's jump right in. I mean, the discussion today, and we'll want to kind of make our way pretty quickly through some of the intro slides because we've got a lot of best practices and how to do this at the back half of the deck. But needless to say, ROT has been, and that term's been around a long time. It feels like it's getting more of its moment on stage here in the last couple years, and so that's what we want to talk about. But certainly, data volumes growing, etc. Rot has not gone away and is in many cases, more prevalent today than ever. And
No, I
yes,
definitely.
we just, sorry, Lisa, we just got a question. The slide deck will be provided at the end, so we're going to go pretty quickly through some of the content. So we'll send that around. We got a quick question on that. Go ahead, Lisa. Sorry to interrupt.
Oh, no, no, you're fine. Definitely, as you said, rot just continues to just grow and get larger. We've all, heard it for so many years, but it just continues to be a huge problem. I think, a big piece of it is, lack of ownership in many instances, and no one knows necessarily why it was there. Or who created it, but it just continues to grow exponentially, and the term of storage is cheap. Well, not necessarily with total cost of ownership and litigation and potential risk of what's sitting there. I think it's something that really organizations are starting to realize that it's just not going to go away. It has to be proactively addressed, and you just have to dive in and start peeling away at it.
Yeah, makes sense. Well, let's keep moving, and hopefully the audience is familiar with this notion and they want to find out what to do about it. Obviously, high risk data is critical here, right? We're not really worried about the interoffice emails for the picnic lunch. We're concerned about sensitive data, and we've got a couple slides to talk about different types of sensitive data. Martin, anything here you want to sort of highlight in particular?
Just real quickly, the notion of what is personal identifiable information or personal data these days is a lot broader than the usual suspects, such as social security number, driver's license, passport numbers. This list, I think, is identifying the usual high risk data that we're all familiar with, but the definitions of what is personal data in jurisdictions like the European Union or California or now many states in the United States is a lot broader than what we would typically and historically think of as personal information or personal data. So that's something that's important to recall, as well as information that has corporate value and corporate sensitivity that may not be governed by statute, but is super important to the company.
Yeah, and also, I don't know if we'll get into this too much, but with AI and large language models and the like, the ability to derive sensitive information also is possible, right? So it's not just your social, it might be buying behavior and gender and location, and in any one piece isn't sensitive, but in the aggregate, you could have some pretty sensitive content, right?
Absolutely. And that's increasingly so.
Okay. All right, well, let's keep moving. Here, again, more of these type of information. One of the things I wanted to highlight, you'll see this often, particularly with information that it's known to be sensitive. It's housed in particular repositories, HR systems, whatever they might be. A lot of the high profile hacks will be derived from convenience copies. So there's a file of um, PII with sensitive information that's supposed to get loaded into a system. It does get loaded into that system. It's now protected. And that file, that convenience copy, tends to sit out on the network. And those are the things that tend to get exposed. And so, yes, a customer list that's in Salesforce is probably being protected pretty well, but you might have extracts and exports that sort of exist out in file shares. So you'll see some of this kind of out there in the wild. All right,
No, I
let's.
agree. That's definitely, causes a lot of different problems. Trying to figure out what is the official system of record, where does the record live, and often I see record retention schedules get misinterpreted. That every version of this particular type of record falls under the schedule, when in fact, it's really this version that lives here in this structured repository, and everything else that you've created is for convenience and temporary transitory, but still needs to be managed and not, just living out there forever.
Yeah, and that's where file shares tend to be particularly dangerous, right? Those are the parking lot of information for the organization. All right, well, let's keep moving. And here, another laundry list. You guys will know that there's tons of different ways to think about sensitive personal information. And Martin, you alluded to some of those newer forms and those changing. I mean, biometric information is probably a better one of the kind of newer ones. Anything else you'd kind of draw out that you've seen more kind of recent, newer data types, modern data, I think sometimes people call it?
Yeah, yeah. So obviously, what we're doing is we're setting the stage. We're at the one of the spectrum talking about rot, which is stuff that isn't even a record, and you probably shouldn't have it. It's temporary in nature, and unfortunately, we end up keeping it longer than we should, and really, it has no business value and should get rid of it. And then the other end of the spectrum, we're talking about what is high risk data, important data, which not only is there the regulatory environment, but let's not forget the contractual environment. I know, Lisa, you'll speak to instances where you may have contractual obligations with your customers, your clients, or even your vendors that impact what you are to keep and not keep and when you dispose of it, which is another important factor. And now we're talking about this new category of data that started across the ocean with GDPR, but is now taken firm root in the United States. California and other states have a new category of not just personal information, but sensitive personal information. So we have these new categories that have some interesting definitions, which are pretty broad, but more specific than general personal information. And they require, particularly close attention and handling and care, and also the type probably most likely to be required not to be over retained because of their sensitive nature. Dean, you hit on one really new one, which is the use of these large language models in generative AI and what pools of information those tools are drawing from in order to do their work, and what the extracts and prompts and things like that are generating from those models, which may not create, well, they are creating new data actually, and they're storing it in interesting places. But it is another category of information that we need to be concerned about from a whole host of perspectives, not only from records retention, but also, for example, responding to a data subject access request or a request to delete.
Yeah, and just real quick, because it's jumping out off the page to me. Anyone seen any case law on the olfactory data yet? Okay, just be aware
I
that
haven't
it is.
seen one on Gate either, although that's one of my favorites.
Okay.
You know, it
All right.
reminds me
Next.
of Aerosmith, "Walk This Way," right?
All right. Next slide.
So I guess
Yeah,
yeah,
go ahead,
I was
Martin.
say, well, I guess what we're getting into here is that now, we understand we have these different types of data, and we've always had an issue with rot. Trying to get rid of rot is as old as rot itself. But now we have a new legal landscape, and we started to hint at this because we have new things like data privacy laws, we have cybersecurity laws, we have biometric information laws, particularly in my home state of Illinois, which has the strictest biometric information privacy law in the entire country. We have these new laws that require and put rules around what you can collect, how you collect it, what you can and can't do with it, and most importantly for this session, when you must dispose of it. And we're going to get into all these things in a little bit more detail in a minute, but there's a new regulatory and legal framework that is in conflict with retention. It's actually going to lead us into a discussion in a minute here on mandatory data minimization.
Yep. Next slide. Okay. Well, you've mentioned this a few times, Martin. At least to my understanding, that the first time I had heard about data minimization was out of the GDPR, and I think this language is really powerful because you see this now promulgated in lots of statutes. Is keeping information only so long as it has a legitimate business purpose. And that's a tough one for organizations, right? Because we've been used to, as the title indicates, hoarding. We kept information to keep it just because, as Lisa, you're saying, storage is cheap. Let's just keep it. We'll figure it. What's that whole saying? Kill them all, let God sort them out. It's like we'll just keep all the information forever till we find someday that we're just going to query it and go find some nugget that we need. That's no longer possible with this new language, correct?
That's right. And it's not just GDPR. We can go to the next slide and start to dig into this a little bit more because it really is going to help frame the conversation for the balance of the day. I mentioned that we have a new legal and regulatory framework. Some of these folks are familiar with, but it's the data minimization pieces that are relatively new, particularly in the United States. As you mentioned, this all started a while back with the GDPR, the General Data Protection Regulation, and you had a quote up there earlier, Dean. But basically, the GDPR has a lot of rules around what you can and can't collect with respect to personal data, what you have to do when you do, how you process it, et cetera, et cetera. But for purpose of this conversation, the key thing is that Article 5.1(e) of the GDPR provides that personal data must be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the personal data are processed, which is important because you have to remember what you collected the data for and what the purpose was. You don't want to be in a situation where you're in your house and you have a closet you haven't been in a long time and there's a box and you don't even remember what's in the box or why you put it in the box. Might be okay with an old sweater, but it is not okay when it comes to personal data. So this has grown, as I mentioned earlier, taken hold in the United States, and we'll just jump around to a couple of places here. The Federal Trade Commission in December of 2022 updated its safeguards rule. Now, this applies to financial institutions, but generally requires those financial institutions to implement procedures to securely dispose of customer information within 2 years of it last using that information. Institutions can keep the information longer, but they need that legitimate business or legal purpose, which we'll touch upon a little bit later. So here's records retention. You right off the bat have a statute that now says you can't keep it any longer than a certain period of time. So you need to know where it is, what it is, when you collected it, and when the clock started ticking on it. But of course, we can't really talk about this subject without going to California. So let's go to California, which of course reminds me of a Led Zeppelin song, but we'll get to that slide. Um, Obviously, the CCPA has been a hallmark in the United States, the first comprehensive consumer data privacy law in our country. Um, there are other laws we'll talk about in a minute that have followed the CCPA, but the important thing about the CCPA is that it contains the first explicit data minimization requirement of any U.S. data privacy law. It's up here on the screen. Basically, thou shall not retain a consumer's personal information or sensitive personal information for each disclosed purpose for which the information was collected for any longer than is reasonably necessary for that disclosed purpose. So very similar to the GDPR requirement. An important update just last year in April, the California Privacy Protection Agency, which is the agency that was created by the CCPA as amended by the CPRA. We're going to play our acronyms today. The CCPA issued or the CPPA, excuse me, issued an enforcement advisory in April of 2024 that really drove home this concept of data minimization as a fundamental principle of the CCPA. The advisory basically states that businesses covered by the CCPA should apply the principle of data minimization to every purpose for which they collect, use, retain, and share consumers' personal information. So if there was any question about the fundamental pillar of data minimization in the CCPA, that advisory last year removed all doubt. And then go to the next slide real fast. We'll continue our journeys here across the country. Most, I'm sure, are familiar by now that as of today, June 3rd, 2025, 20 U.S. states have enacted comprehensive data privacy laws that are designed to increase consumer protection. Only two of those states, Rhode Island and Utah, do not include express requirements for data minimization or purpose limitation. So that concept we just talked about in the GDPR and the CCPA is present in other states, many other states. So it's kind of hard to get away from these days. I recall people saying, well, I don't really need to worry about California, do I? And I would remind them, well, it is the fifth largest economy in the world. But if you want to ignore California, do so at your own risk. It's really hard to ignore it now. It's become a steadfast reality that we have to address. And then last but not least, I do have to mention my home state of Illinois again. The Illinois Biometric Information Privacy Act goes even further and deals with biometric identifiers and biometric information and has specific requirements, again, like the FTC safeguards, where not only do you have to have a records retention policy in place and a policy in place for how you're going to handle biometric information you collect, but there is a limit on how long you can keep it. For example, the statute requires destroying an individual's biometric identifiers or information at the earlier of satisfying the purpose of the collection or within 3 years of the last interaction between the individual and the entity. So think of an employer who gets biometric information for purposes of biometric time clocks, clocking in and clocking out. If somebody leaves, you have to get rid of that biometric information within a certain period of time or potentially face large financial consequences. So this brings us to the next slide, which is really what we want to focus on going forward in the next few slides is, okay, how are these data protection requirements that we just went through real quickly shaping information governance? I'm going to mention a couple things and then hand the microphone back to Lisa and Dean to comment further. But what we're seeing, of course, is an increased focus on privacy. I already mentioned the data minimization requirements and policies. And the ability to document and survive audits that things are being handled properly in terms of both retention, but also disposition are increasingly important and being challenged by regulatory authorities.
Yeah, I mean, Martin, there's a lot there, and thanks kind of for the tour de force to get us to this point. I mean, to me, you mentioned tension. I feel like, and this is what we're seeing sort of in the field, is the tension between I need to keep it for a legitimate business purpose, but how do I divine that? And that really is giving the stage to and some additional focus on record retention schedules, because your retention schedule should, if done well, should talk about why you're keeping different categories of information and how long, and that should sort of there should be the yin and yang between data minimization and your record retention schedule. And so what I've seen in practice is that some people want to go very quickly into their data privacy minimization standpoint, and then the question is like, well, okay, how long should we keep it and are we keeping it? And it gets them into this sort of cycle of, am I thinking about my record retention and data minimization and data privacy? And those can be siloed. And so it requires kind of going back to first principles. And Lisa, I know you've got the records management chops. I mean, that
Mhm.
kind of puts you and your sort of sphere of influence back in the limelight to say, hey, we got to get the records piece sorted before we can kind of do anything else. Is that right?
Definitely. I think that retention schedules are definitely evolving to, very, very important. What is the legal requirement? And having that documented. And if you have, records that are, if there's a business area that wants to keep things longer than that required period, having clear documentation around the justification for that. Privacy enabled retention schedules are becoming very common, like by record category, having, it doesn't have to be extensive, but a small explanation of the reason why. And many of the reasons are because this legal requirement says we need to do it. But when you run into, we just want to keep it 10 years or 15 years just because, those answers really aren't sufficient anymore. So I think having that documentation around the reasoning, and it's a little more challenging with record categories that don't really have any legal requirement. It's solely based on business need. But I think having that documentation, truly understanding who the subject matter experts are, which business areas are responsible for the different parts of the schedule. I think it's become more critical to really have that very thorough understanding of the reason and justification behind those retention periods.
Yeah, and Lisa, I mean, to the extent you're comfortable talking about it, I mean, there's so many groups then because you've got the records and record retention, sort of short-term, long-term digital preservation, which is kind of a whole separate animal. Um, and then you've got data privacy, and then you've got sort of audit and compliance. I mean, how do you think about making sure you've got all the people in the room with all the various facets of what their maybe legitimate business purpose is? Oh, never mind legal hold, right? You have legal hold
Right.
on top of that, which is
Hmm.
the suspend thing. So how do you get everybody kind of in the room to get their perspective and buy-in?
Yeah, I think that having those relationships built with those key critical areas is so important. Often, what you'll find is everyone is kind of working towards the same end goal, but they're not necessarily communicating. So, bringing those groups together, if steering committees, having information governance steering with representation from all of those critical areas. If you can't, I know steering committees are hard. I've in my prior role, we had a lot of false starts of, standing up a steering committee and, taking care of it and keeping it, the momentum going can be challenging. But even, if you can't have a formal steering committee, having, very open lines of communication, knowing who those key stakeholders are, I think that it's so important to have everyone aligned. Records management historically are very small teams, small and mighty, but you need to have, records management's everyone's responsibility and information governance. And the more solid working relationships you have with those different areas, the better and more solid and defensible your program will be.
All right, let's go to the next slides because I know there's not only
Before
doing.
we do,
Go ahead,
Dean,
Martin.
just a couple of
Yeah.
important things here. I think they're worth highlighting before we get to enforcement and penalties, which of
Sure.
course is the shock and awe portion of today's presentation. Two things here, and Lisa, you touched upon it. So we have a couple of tension. Actually, you both touched upon it. Number one, we have the tension between minimization and retention, and obviously, the data minimization requirements in most data privacy statutes say you have to get rid of it unless there's a legitimate purpose or some other lawfully required reason. Um, And then we have retention requirements in a lot of different places, like the OSHA example that's up here on the screen. But here's the challenge I see coming up, and something that hasn't been tested yet, to my knowledge, but probably will, is okay, how many people in organizations have records in multiple jurisdictions? And say Arkansas says to keep a record for 2 years, but California says to keep it for 10 years. How many of us have just said, you know what, rather than try to manage state by state, we're just going to go to the longest retention period and handle everybody that way? That makes perfect administrative sense and it's very convenient. But does that, how does that hold water with a data minimization requirement? So if Arkansas says, hey, we have data minimization, why are you keeping it for another 8 years just for your administrative convenience because California said to keep it longer? I haven't seen that tested yet, but I think that's something we may see someday. The other thing that is interesting and very important that you mentioned, Lisa, is not only be able to articulate what that legitimate purpose is or what that other lawful requirement or other legal requirement or obligation is for keeping something longer than you might otherwise, is being able to articulate what that is, documenting that, and then can you defend that if ever challenged? And again, we're still in the early stages. But I think we're going to see eventually some challenges by regulators as to, okay, you say you have a legitimate purpose, you say that you have some other legal obligation, even a legal hold. Is that legal hold properly scoped? I mean, do you really need to have it as broad as you do? These are some of the questions that we're hearing already coming out of this conflict between retention and minimization.
Yeah, let's because I hadn't thought about this one yet, Martin. It's a really interesting one with legal hold. I have seen organizations will say like we're on perpetual legal hold and we can never delete anything, which is possibly practical, but also kind of a cop out. And how would you see? You could see a challenge to that, right? Where the the if it's not scoped properly, does the entire company need to be on legal hold in perpetuity? I mean, I know it's easier because okay, we're never going to delete anything because we've got litigation. So that seems to be a pretty interesting another tension here that we're calling out.
Absolutely.
And then over retention, right? You know some of these you're seeing them kind of any one of these you want to highlight in particular, Martin?
Yeah, I won't spend a lot of time on these because the point is kind of the same. The four examples that we have here are all enforcement actions either brought by the Federal Trade Commission or by the New York Attorney General or the California Attorney General. But in each case, it was a situation where a regulator went after someone and penalized them for, among other things, over retention of personal information. While you might not think of the FTC as a privacy act per se, I mean, the FTC has literally been America's privacy cop for some time now and considers over retention of personal information, particularly when you suggest otherwise in your outward facing comments, to be an unfair method of competition or an unfair deceptive practice. So the FTC has been enforcing data minimization requirements. And where do these come up? Well, as Dean, as you alluded to earlier, usually there's a data breach. So you have a data breach, which is bad enough, and you're dealing with that mess and everything that comes out of it. But then you end up having an enforcement agency say, hey, you know, all that personal information that was exposed due to your poor security measures. Well, I got more news for you. You exposed a bunch of data that you shouldn't have been keeping as long as you did. So the IMED, Weight Watchers, Cafe Press, and Blackbaud cases are all situations where someone was penalized between mid to high six figures and in some cases blackballed millions of dollars for data breaches that expose personal information that the regulators determined that the company had unnecessarily retained for longer than necessary. That's redundant, but you know what I mean. So what it shows is that there's teeth and real financial penalties to over retention.
Yeah, and this is another interesting tension to me. When you talk to cyber folks, there's a whole notion of assume breach, right? You need to assume that you will be breached or you already have been breached and you just don't know about it. So if that's the reality, and I think most practitioners would say that that is the reality, then all this data you're sitting on will come to light, sadly, in a breach sometime soon. So if you're not getting ahead of this now, you're basically waiting for the breach to happen and then hoping that the regulators, take mercy on you. Because it's not in the, whatever decade ago, you're like, yeah, I won't get breached. It'll be one of my neighbors. Right now, everyone's getting breached, and these will all come home to roost here pretty soon. All right, let's go to next. All right, so setting the stage for dispensable disposition. So obviously we use the defensible in there. I mean, there are tensions. So, and this is why there's legal requirements, both records retention, legal hold, um, the, all the various things you need to consider are important. That being said, you do need to get rid of information. It's not a option any longer. And to me, for the last decade or so, it was always optionally. Like I'll have good records and information hygiene, and I'll clean up, and no one else is cleaning up. And so we would see a lot of companies do that. At least I don't know if you saw that in your past. And so forward-thinking companies were already ahead of the curve, but that feels like no longer the case. And maybe that's part of building this case for disposition is this is not like hygiene, like we might want to do it. This is a must do versus a nice to do.
No, it's definitely a must do, but also must do it thoughtfully and defensively, and have the necessary documentation in place. I mean, it's so important to be having your disposition align with retention requirements and not just keeping things around. But it's also important to make sure that you have the right stakeholders involved, that what it is that you're deleting, and verifying that it has met those necessary requirements. I think if you don't know where to start, because sometimes it's just overwhelming, taking a risk-based approach, to either going for the low-hanging fruit things that are easy quick wins, but also when you're looking at the whole magnitude of it, focusing on those repositories that have a lot of sensitive data, or maybe older applications, legacy systems that have migrated to somewhere else, or were just kept just in case. Those are good areas to focus. But I think it's critically important that you have management support all the way up to the top. Setting the tone at the top is critical, because often, especially when you're destroying or disposing from digital applications, you need IT support and you need funding. But the sooner you can have a regular, repeatable, documented process in place, the more defensible position you'll be in.
Yeah, and don't you encounter this? You've got the knowledge workers at the organization and different various factions. They don't want you to get rid of anything because there's this fear. That's why we're hoarders, right? I don't know,
Yeah.
we go back to the caveman days or something, but like we don't want to, we created a PowerPoint 5 years ago and we don't want to like ever get rid of it because there's just some weird, probably not rational, fear of losing stuff.
I
And so
like the font.
yeah.
Right.
So how do you get past that? Because it's always, to me, it's always been this, is the data going to help us or hurt us? Right. And
Hmm.
you could make the case either way, depending on your experience in your past company. Like 10 years ago, there was this, I found the smoking gun exculpatory email that we kept around and it was great and it got us out of a case. Right. So there's always those kind of like the stories that are sort of a visceral. How do you sort of counter that?
It is challenging. There's always going to be that one time, but I think you have to balance the whole picture of there might be that one thing, but keeping so much for so long with no justified reason, generally it just becomes rot and it just accumulates over time. It's long forgotten. No one knows why they have it. I think for many years the culture of a lot of organizations was just to keep everything just in case we might need analytics, we might need this, and it was just the way things were done for so many years across the board. Everyone just kept everything, and now decades into this, it's just an overwhelming situation. But beginning to apply your policy and consistently, not sporadically here and there, because if you're applying retention in one spot and you're not doing it somewhere else, it really then questions the whole program.
Yeah, and Lisa, one of the things I used to hear is, and this was a while ago, but people say like, we're gonna keep all this data, and then one day AI will be at such a level of maturity that we'll just point it to the organization just in general, and it will divine answers to all of our problems. And I think you guys can correct me if I'm wrong. What we're seeing now is the need to curate that data because if you throw AI onto rot, you're going to get, it's all garbage in, garbage out, but you get data hallucinations and you'll get sensitive data that was in there that you don't want to expose your AI to, et cetera, et cetera. So this kind of notion of we'll make use of it at some point in time really isn't the case. What we're seeing now more than ever with AI, it's a project you're failing because the data is not being properly pruned and hygiened
Right,
and curated. Hygiene, I just made up a word, but it's not being curated, right? And
right.
and that is part of this rot. Is like we've got to get rid of it for a bunch of reasons, but also for the people who want answers, you have to have clean data here to point your other systems at.
That's a really good point, Dean. And I just have to address the urban legend of there was this one time we found one document that got us out of a lawsuit. As a litigator, I will tell you that there's maybe 20 times where just the opposite happens, and that exposing the requesting party or the plaintiffs to a whole bunch of data that they otherwise wouldn't see or you wouldn't have to review. Actually does the opposite. It identifies things that create more headaches than they do solve problems. And frankly, in some of the large cases that I'm involved in, uh, exposing those unnecessarily exposing those data corpuses or corpi to plaintiffs' counsel just means you're giving them fodder for their next lawsuit.
Right. And especially if you don't understand the data and you just exposed it to them, they're going to be mining it. Like it'd be one thing if you understood it perfectly, but oftentimes you don't, right? They're going to spend more time mining it, looking for nuggets that are maybe harmful to your case, your position as well. All right, let's go to next. We've got some questions coming in, so we'll make sure we hit those at the end. Want to ensure that we have enough time. I think, Lisa, you might have mentioned this sort of low-hanging fruit. What we're seeing when people deploy software, so what Gimmal does is has software, not surprisingly, that can identify and remediate rot. There's other companies that do this as well. It's fundamentally not that difficult technologically. Um, the challenge often is to get the support and the buy-in and the use case and all the other things that we mentioned before, sort of the consensus for the program. One of the things that we see practically working is this, let's go after, create a quadrant of what's the riskiest data that you have that's the easiest to remediate. There's obviously the gray area and that stuff that's hard. Fine, that will always be hard, but there's these gigantic swaths of information that file share is a perfect example. These unstructured, user-based, custodian created data, convenience copies, all the things we've talked about that we know that are out there, we know that are dangerous, we know that there is no legitimate reason, business reason to have it. As an example, Martin, I think you talked about records retention of 10 years. If your high water mark across all your record retention schedules is 10 years and you have data that's 11 years old, what are you doing? There is just by if your creation date or last access date or file type, or there's a bunch of things that you can look at that are profoundly indicative that this information is not relevant or subject to any of your schedules. One of the things we talked about is inaccessible file types. So if you have Word data that exists, um, and you no longer have the software to access Word data, it's probably pretty apparent that you're not using it for any legitimate business purpose, so you should just get rid of it. And there's a ton of those sort of easy wins that I would say is the place to start. And I don't know, Martin or Lisa, if you have that experience as well.
No, definitely. I think there are, a lot of quote easy wins. I mean, nothing is easy in this space, but as start doing it, I worked on a pretty extensive unstructured remediation project years ago. We had, you're right. The tools they're excellent. They can find it, but it's more the process around it and developing the repeatable process of, how are we going to do it? We're going to take this file share, and this particular department, their longest retention period is 7 years. So we're going to look at, everything over 7 years. And sometimes that volume is huge. But figuring out ways to work with the business area, because you can really go through large volumes without looking at every single thing. And most of these tools, pretty easily can identify where the sensitive data lives in those files as well, and what things are likely hits for, social security numbers and banking information. So you can prioritize those, ahead of things, knowing when you go in, if the area has no legal holds in place, their longest retention is X, taking more of the approach of, we are going to dispose of these files that meet this criteria unless you tell us otherwise. But having that, process in place of, holding meetings, having templates to work from, and then repeating it. But it's hard to keep the momentum going for sure.
Well, I think let's talk about that, because I think in order to keep the momentum going, you've got to get started, right? And so one of the things we've got a program called 8 Weeks to Delete. We're working with people to be able to get to the point where you can push the first button and delete something. Like, what is the most profoundly irrelevant thing that you've got in your organization? Is it a file that is of a file type that you no longer need, that's 50 years old, that is in the system that's decommissioned, right? Pick whatever the easiest thing is. And Lisa, I actually like the departmental kind of approach, because it's sometimes
Mhm.
easier to make those decisions. And then another thing, I think Misty asked this question. By the way, Misty Dawn, great name. It's very alliterative. Um, just made this comment about having people get comfortable, in essence, with getting rid of things.
Right.
We see a lot of people will have kind of a quarantine period. So when you push the button, it's deleted, but it's not actually deleted. It goes into a quarantine area that sits for 30, 60, 90 days. And then if no one says anything, then it eventually gets deleted. It's kind of like your iPhone when you delete pictures, right? In
Mhm.
case you didn't know, they're all there for a certain amount of time. So it gives you this period of like, oh my goodness, I can go save it. But no one ever needs to save it. They just
Right.
want to know that they can conceptually save it. So that's one of the things we've seen is just get a lap around the track and then start getting people comfortable with, like, oh, I don't ever actually really need to go into my iPhone and find pictures I've deleted. I'm pretty good at, once I delete them, that they're gone. I don't know, Martin or Lisa, if you've got any experience along those lines.
Well,
I
I was
definitely
going to go ahead, Lisa.
I'll be real quick. I was just going to say, and I stole the phrase from Bennett Borden, who I used to work with years ago, but his favorite phrase is quarantine and quack. You're going to put it over here, and if nobody quacks or complains, then, after X number of days, then it can go. And when we followed that approach, in my role, like, it was very rare, if not never, rarely did someone need that back. It's just generally, it's mostly just garbage, and they don't even realize that it's gone.
Right.
And the other thing I found with doing those unstructured cleanups, when you really start digging into things, the things you find, like, we found full copies of file shares that maybe were restored by IT at some point, and, buried in a folder 17 levels deep was an entire replicate copy of the whole drive. So you really find, a lot of things that are just definitely have no business value when you start, opening the door and seeing what's behind the curtain.
Just to add a
Yeah.
few things to pick up on what Lisa said, that whole quarantine process is terrific. And if your experience and statistics show that almost never does anyone ask for something in quarantine, you can use that for your defensibility and to increase your comfort level for why it is okay to get rid of things, because it's not just anecdotal. It's, look, we actually put all this stuff, all these terabytes of information into quarantine, and nobody asked for it during the quarantine period. That's really important for getting comfort, as well as, let's celebrate that it's been 20 years since the U.S. Supreme Court in Arthur Anderson versus the United States said it's okay to delete things, and it's not wrongful for a manager to instruct employees to comply with a valid document retention policy, even if the policy is in part designed to keep information out of the hands of others, including the government. So we've had that for 20 years. It is okay to delete things as long as you're not obligated to keep it for legal, statutory, or legal hold purposes, or it has business value. And you don't have to be perfect. That's the other thing that I see that contributes to decision paralysis oftentimes, Dean, is it may be on hold. It may be on hold. I don't know. But just to take the Federal Rules of Civil Procedure, Rule 37E, it doesn't require perfection. It requires reasonable steps be taken to preserve unique, relevant information. And if you are going through the kind of repeatable processes that are well thought out and documented, like Lisa was describing, that sounds pretty reasonable. And if something just happens to inadvertently get lost despite reasonable steps, it's not supposed to lead to sanctions. So yes, there are things like date ranges, and other things that are very important to address. I have to give my 2 cents to the data map. Years ago, we used to all talk about data maps and how wonderful they were, but everybody thought they were stupid because they were like new cars. They decreased in value the minute you drove them off the lot. But data maps are back, because how do you accomplish any of these things unless you know what you have where, particularly responding to a data subject access request? And just one thing on the last slide that I don't want to get lost is that we don't have to go back to it. Is don't forget about your information in the hands of third parties, your law firms, your accountants, your consultants, your vendors, because you may be doing a great job, like Lisa and her organization, of getting rid of stuff. But if you have parties that you do business with that they are keeping your data for longer than you are, that's not good, especially if you don't know about it.
Yeah, couldn't agree more. That sort of soft underbelly, right? You can have your house in order, but if somebody's got a copy of your data and they get breached, then it's all for naught.
Or
Let's go.
subpoenaed.
Yeah, let's go to next, and we'll start kind of taking this home. We want to make sure we can get to some of the questions as well. I like sort of the risk-based approach, Lisa. You talked about that early on. One thing I'm going to throw out here, because Martin talked about actually having data to support your arguments. One of the things that we'll see is when we do, and if anyone wants to do this, we can happy to do this for them. We can do a proof of concept and look at a business unit and a subset of data and tell you exactly what your rot percentage is. If Lisa, if I asked you or Martin, you probably give me different stats, right? 32% or 74%, like whatever those numbers are you've seen either within your organization, you've seen out there generally, rules of thumb, etc. Really powerful to say, we looked at the HR department in this region, in the Ann Arbor office, and there happened to be 74% rot and data kept beyond our, furthest retention schedules because we queried it, right? That's very useful as people build the business case, because no one wants to believe rules of thumb because they want to all think we're special snowflakes. And if somebody else has rot, like our rot isn't as bad as theirs, maybe it's probably worse, who knows? But get that actual data, and there's ways to do that as you start this process. And that's kind of the sampling here that then
Yeah,
to look at sets, right? It's like, look, it's not hard. A lot of this you can do in a day or two, even across big swaths of data, and
right,
then know that your rot is at a certain percentage, and then you can build a business case. You can say, look at 34% rot reduction, all the wonderful things we're doing for the business, but look at our storage savings. That's often the
right.
sort of coup de grace that gets people moving is storage used to be cheap. I don't know if anyone's looked at their Azure bills lately. It's not. There's a lot of zeros on those checks you're writing your storage providers.
Yeah, that's absolutely right. But also goes to defensibility, because those kinds of metrics and statistics can help defend your practices as long as Lisa mentioned, you're doing them in a consistent and repeatable fashion, which leads me into my next point. I am a fan of auto classification and auto delete, because if those are well thought out, consistently deployed processes, they can take a lot of the fear and a reluctance out of the hands of the humans and have stuff go away as it should. And you can back that up with the kind of metrics that you mentioned, Dean. Of course, I have to say that if you have auto delete in place, you must be able to suspend it if required by a preservation obligation stemming from a legal hold.
Very Zubalake-esque of you, Martin. Sorry to throw back to the old days. I just haven't said Zubalake in a while. But that's good. Let's go on the next slide. I want to make sure we get to key takeaways and be able to answer questions. There's a bunch of things on here. Let's start with you, Lisa. Where would you pick kind of a la carte? What would you hit first, or most importantly?
I think that just starting, just start somewhere. Be it, file shares. If you're looking at the file shares, start with maybe orphaned abandoned file shares. Everyone has ones that don't even have an owner anymore. No one knows who owns them, why they were there. That's one place that you can start. I think leveraging the different tools that are out there in the industry, they've come such a long way. There are very, very good tools trying to, manually look through spreadsheets and exports of files on file shares. You'll just never get there, but leverage automation and resources that are available to help you move through things more quickly. I think that having those relationships are so critical, with the different areas, being closely tied with IT, because all of these situations are mostly related to technology, and having that seat at the table when older systems are being decommissioned and new systems are coming in, right there at the front, is where you really need to be inserted, to ensure the right things are being migrated, and to have a good understanding about what is being left behind in the legacy tool, to have a plan, so it doesn't just go to some digital graveyard. And equally important, I think, to have a seat at the table when brand new applications are coming in, addressing retention and deletion settings and legal hold. All of those technical requirements are better to get it on the front end. Very often you're getting people are reaching out when it's not too late, but certainly if you're up there in the initial requirements, gathering, and make these be actual requirements, I think that certainly helps the situation a lot.
Yeah, well, why don't I'll throw one in, and then Martin, you can round us out, and then we'll jump into questions. Lisa, you hit a bunch of things I like there. If I were to synthesize some of that, it's find an inflection point, right? It's the digital transformation. It's a migration off an old system to a new system. It's a failed audit. It's it's something, because everyone, it's why so many people go on diets on January 1st, right? They make a New Year's resolution, and that's their inflection point, right? There's no different between one day and the next, but they find that as an inflection point. And so find an inflection point within your organization and use that to jump in. And it's like, now's our time to kind of get moving on this. Um, and the digital transformation and systems changes are perfect ones, right? Let's not replicate
Right.
this. If you're moving your house, you've never cleaned up your garage before. Well, now's the time. We're about to move, put everything in boxes. Maybe we should throw a bunch of stuff away, right? That's the great kind of equalizer in some of the discussions. And to me, when we see customers really acting, they're often hijacking one of those kind of inflection points. Martin, why don't you hit your key takeaways, and then we'll leave a couple minutes for mop up for questions.
Sure. And I'll pick up where you left off, Dean. I agree completely that one way to solve the decision paralysis is not to try to do it all at once, but start with go with prospective. Okay, maybe you have a bunch of data lakes that you're really having a hard time getting your arms around, but that shouldn't prevent you from starting today going forward to do better with new systems. And there was a question in the chat about addressing retention at initiation. The ability to assign retention labels and make retention decisions when data is created is terrific, particularly the initial decision between is it a record or is it not a record? And having a good definition for what's a record, and then how long should that type of record be kept? If you can do that at the outset, that goes a long way towards helping this solution. And then you can focus over time on what you learn and the metrics and defensible outcomes that you develop through your prospective work. You can start to apply that retrospectively to tackle data lakes and other things. So I agree with you, Dean, particularly when someone migrates maybe from M365 on-prem to the cloud is a really good time to look at, well, why are we keeping this stuff? Can we keep less of it? And do we really have to move it because it's a pain to do that? That can be a great motivator. The only other thing I'll mention is it's the third bullet point on this slide is when you do dispose of something, and most things are electronic these days, but they're still paper, it needs to be done appropriately and up to industry standards. Just hitting delete may not be good enough, but have a good understanding of what the standards are for electronic sanitation of different storage devices and places. There are NIST standards that get updated periodically for what that is, and it's important, particularly with sensitive or confidential or personally identifiable information, for that information to be disposed of and deleted up to a particular standard.
Yeah, and Martin, on that, do you ever find that people will look to counsel for kind of a disposition letter, like that it's okay that we have a policy and it's okay? Do you think that's necessary? I've heard people talk about that before.
We have done some of that work for clients. It's usually in the realm of either a system migration and not moving everything over and getting some defensibility around that so that it just bolsters and not only the company did it in a thoughtful and mindful way, but they also got outside counsel to give them their view on it. But particularly in rescoping legal holds, uh, we get bold into that quite a bit where clients have these legal holds, and I don't want to talk about overlapping legal holds, which is one of the reasons when a legal hold is lifted to actually act to release it and anything that you wouldn't be keeping according to ordinary retention as soon as possible. Because if you're a serial litigant, another lawsuit can come in, and now what you just released is now covered by another legal hold, which can become an impossible situation. But we do work with clients quite a bit to rescope legal holds and to provide some additional comfort on letting things go.
Okay, great. Well, and as we start to wrap up here, please chime in with questions either in the webinar chat or the Q&A platform. We have no questions in the Q&A platform, so that makes me afraid that it's not working or people don't know how to make it work. But you can drop in the chat if you want as well. And as we noted at the beginning, we will make this um, PowerPoint available to everybody. And then I'm sure Lisa and Martin can, if you guys have any questions and want to reach out to either of our panelists, they're happy to, I'm sure, help you in your in their off hours, kind of figure out some of your challenges. Let's say, yeah, thanks, Misty. We've been hitting most of the questions as we went, so that's good. And I think we can just start to wrap. We'll give it a second or two as we have any final closing comments. Let's wrap with Lisa, if you have any closing comments for the audience today.
I think we covered a lot of ground. I would say just do it. Just get started. Um, get those small wins. Building the relationships, I think, is the most critical piece. Making sure you have, all of the right people at the table. But don't be afraid just to get started. It can be overwhelming, but I think taking those first steps and moving, towards it gets a little bit easier as time goes on. And the most critical thing is really to have your documentation in place. Have that consistent, repeatable process, even if it's not perfect. If you're making, the same mistake, but it's part of your repeatable process, and you learn as you go, and you improve, and you document, you're still in a very defensible position.
Okay, well, before Martin will allow you to wrap up, we got a couple questions. I was stalling, and now we got a couple questions coming in. We got one on the screen. How would a company manage cutting back on paper documentation with all the cyber issues in today's environment? I mean,
Yeah,
we need it documented. Do we need it papered per se? I mean, you don't need formal memos. You just need some record of your process, right? And that it was
yeah, I
followed.
think maybe it's more about, there is still a surprising amount of paper out there. I think
Mhm.
we all, everybody thought, there wouldn't be paper, as far as the documentation around the process, having that digitally and storing it. But uh, transitioning from, paper records, I think is still, it's still surprisingly more volume in paper than we would have expected. But certainly having records digitally is important. Managing and applying those same retention requirements around the paper so that you're not keeping extraneous duplicate copies of things that generally aren't necessary. And having the secure digital repositories, knowing that you've got, the necessary security in place, so that you can remediate the paper and not just keep it, tucked away in some offsite storage somewhere indefinitely, because there is certainly risk around that as well. You want to manage your records in all formats.
Yeah, and we're right here at the top of the hour, and Martin, maybe we can you might be able to get this to the person who asked it, but they asked about stories like the Blackbaud case, specific to state and local government, right? Everyone's looking for like the super tangible example where their neighbor gets broken into. It's not good enough that it's, somebody in the neighboring county, right? They want a real tangible example. So maybe we can answer that one offline. But it's top of the hour. I want to be respectful of everybody's time. Thank you for all the attendees joining today, and then Lisa and Martin, really appreciate your time and the
Thanks for
comments you
having
shared
us.
with the group here today.
Thank you, everyone.
All right,
Thank you very
thanks
much.
all. Have a good day. Cheers.
Cheers.
Bye.
Bye.